Thank you for joining us for this overview of Form I-956G, Regional Center Annual Statement. I will go through the presentation today, reading the information on the slides and adding additional information. Let's start with some of the preliminary general matters that pertain to Form I-956G. Form I-956G is a USCIS form that was newly created following enactment of the EB-5 Reform and Integrity Act of 2022, the RIA, and was first published on June 1, 2022. The goal today is to provide guidance regarding the Form I-956G. Please note that throughout the presentation we may say Form instead of I-956G. When we say Form, we refer to Form I-956G. If any other form is mentioned, the form number and name will be provided. It is recommended that you have a copy of the Form I-956G and instructions available to reference during this presentation. The information shared in this presentation is intended solely for the purposes of illustration and does not create or supersede agency policy with respect to the I-956G form, form instructions, or applicable statutes. As a reminder, please consult these and other USCIS sources for additional information. Similar to the prior Form I-924A, the Form I-956G is the form regional centers use to submit the annual statement of their activities for the prior fiscal year. All designated regional centers must use Form I-956G to provide the required information, certifications, and evidence to support their continued eligibility for regional center designation. Each designated regional center must file Form I-956G for each federal fiscal year, which means October 1st through September 30th, on or before December 29th of the calendar year in which the federal fiscal year ended. Failure to file the I-956G may result in sanctions, including the termination of the regional center's designation. The form instructions clarify that legible photocopies should be submitted. The I-956G instructions also state that if the regional center submits original documents that are not required and not requested by USCIS, USCIS may destroy those original documents upon receipt. You may notice that the new instructions do not require that the regional center submit any original documents along with the form. Therefore, when filing I-956G, do not send your original documents unless specifically requested by USCIS. If USCIS specifically requires original documents, they will be returned to you after the adjudication process is complete. The information USCIS collects on the form is required by the EB-5 Reform and Integrity Act of 2022, signed into law by President Biden on March 15, 2022. USCIS will use the information provided to determine the regional center's continued eligibility for regional center designation. The identifying information on this form relating to the qualified certifiers and authorized individuals will allow USCIS to conduct standard background checks with law enforcement, which may uncover derogatory information that may result in the termination of the regional center's designation. Now, let's discuss the different parts of the form itself. Part 1 of the form requires regional centers to select the form type being submitted. Regional centers should select Annual Certification of a Regional Center if the regional center is filing its initial I-956G for the annual reporting period. Sometimes a correction may be needed to the regional center's previously submitted I-956G. In these instances, regional centers should select Amendment or Supplement to a previously filed annual certification of a regional center. For both types of forms, regional centers should ensure they enter the correct fiscal year on the form. Failure to provide the correct fiscal year may result in a request for clarification and otherwise delay the review of the form. The form specifically asks for the legal name of the regional center entity as written on the entity's certificate of organization or incorporation. The Regional Center Identification Number must be accurately entered in Item 2 of Part 20 of the form. The Regional Center Identification Number, or RCID, is a unique 10-digit number. You can find the RCID located on official USCIS correspondence. The Regional Center must provide the complete and accurate mailing address where it can receive correspondence from USCIS. If the Regional Center's physical address is the same as the mailing address, select the box to indicate so. If the physical address is different, the applicant must provide the mailing address in this Part 2 and the physical address in Part 8, additional information. The Regional Center should also ensure all other requested information is provided. USCIS now assumes that most, if not all, regional centers have an email address and a website. USCIS is especially interested in any email addresses so that USCIS may contact the Regional Center via email about its annual filing, if necessary. USCIS may contact the Regional Center via email to ask questions about filing, issue a request for information, or a request for clarification. The Regional Center has the option to reply to a request for information or clarification by requesting that a formal request for evidence be issued instead. Part 3 requires information about the Regional Center's operations. Regional centers must provide the aggregate amount of EB-5 capital that has been invested in the Regional Center. This amount should be from the time of the Regional Center's initial designation and not simply the amount of capital invested in the preceding fiscal year. Part 3 requires regional centers to disclose any pending material litigation or bankruptcy proceedings, or such proceedings that were resolved in the preceding fiscal year involving the Regional Center, NCEs, or affiliated JCEs. Second, the Regional Center must describe the policies and procedures in place to ensure compliance with all applicable federal labor laws. If a regional center prefers to explain any material litigation or bankruptcies or the compliance policies in any supporting evidence accompanying the I-956G filing, such as an operational plan or administrative plan, they are free to do so. If so, regional centers should select the appropriate box indicating that they are submitting supporting documentation providing this information. They should also clearly describe the type of documentation being submitted and where it can be found in the file by providing the exhibit number and the name or title of the document where this information is provided. If the Regional Center is not submitting separate documentation providing this information, the Regional Center should provide this information directly on the I-956G form in the text boxes provided. If more space is needed than the text boxes provided, regional centers should use Part 8, additional information. Part 3 also asks about the number of Attachment 1s being submitted with the I-956G. Attachment 1 is a form attachment to the I-956G to be used by a regional center to provide information on each capital investment project being undertaken by NCEs under the Regional Center sponsorship with active EB-5 investors. For purposes of this form, USCIS considers an active EB-5 investor to be any investor who is seeking classification under INA 203b5 or who has obtained conditional permanent resident status but has not yet filed for removal of conditions. The Regional Center must attach a completed copy of Attachment 1, information about each new commercial enterprise and capital investment project, for each separate and distinct capital investment project being undertaken by each new commercial enterprise sponsored by the Regional Center. For example, if the Regional Center sponsored 3 NCEs, each undertaking 1 capital investment project with active EB-5 investors in the preceding fiscal year, they should submit 3 separate Attachment 1s, one for each capital investment project being undertaken by each NCE, or if the Regional Center sponsored one NCE that was undertaking two capital investment projects with active EB5 investors in the preceding fiscal year, they should submit two separate Attachment 1s, one for each capital investment project being undertaken by the NCE. Regional centers should indicate in Part 3, Item 4, the total number of Attachment 1s being submitted with their I-956G. Part 4 requires 3 separate certifications and the signatures of qualified certifiers. A qualified certifier is a person in a position of substantive authority for the management or operations of the Regional Center, such as a Principal Executive Officer or Principal Financial Officer, with knowledge of the Regional Center entity's policies and procedures related to compliance with applicable requirements. The I-956G also requires the qualified certifier's identifying information and contact information. Although the 3 certifications relate to different aspects of the Regional Center's operations, the qualified certifier may be the same for all 3 required certifications. The first certification relates to bona fides and foreign involvement for persons involved with the Regional Center. The qualified certifier must certify that, to the best of their knowledge after a due diligence investigation, the Regional Center is in compliance with INA Sections 203B5H1 and 2. The second is the Securities Laws Compliance Certification. The qualified certifier must certify that, to the best of their knowledge after a due diligence investigation, all offers, purchases, and sales of, and investment advice relating to, securities made by parties associated with the Regional Center complied with the securities laws of the U.S. and any states in which applicable securities activities were conducted, the issue of securities was located, or the investment advice was provided, and that all records, data, and information related to those securities activities have been maintained. Finally, the third certification relates to direct and third-party promoters and requires certification that, to the best of the qualified certifier's knowledge after due diligence investigation, the Regional Center is in compliance with INA Section 203B5K3. Like the prior Form I-924A, the Form I-956G requires the signature of an authorized individual who has been granted the authority to file the form on behalf of the Regional Center. The I-956G requires the authorized individual's identifying information in Part 5. The authorized individual may or may not be the same individual acting as the qualified certifier earlier. If the individual is the same, the individual must still provide their identifying information and contact information in both sections. If the authorized individual does not understand English and had an interpreter assist in the reading of questions and the filling out of the form, select the appropriate box and provide the language of interpretation. The interpreter must then complete Part 6. If the authorized individual is not filling out the form themselves, then the authorized individual must select the appropriate box and provide the name of the preparer who prepared the application. The preparer may be an attorney for the Regional Center. The preparer must then complete Part 7. If the same person was the interpreter and preparer, that person should complete both Part 6 and 7. The authorized individual must also declare, among other things, that they recognize USCIS authority to conduct audits using publicly available information, and recognize that USCIS may verify information through any means determined appropriate by USCIS, including, but not limited to, on-site visits. Please note that even if a different individual prepared the form, it is still the authorized individual's responsibility to declare, under penalty of perjury, that all information contained in the form is complete, true, and correct, and that they are authorized to file on behalf of the organization. If the authorized individual used an interpreter to read and/or fill out any portion of the I-956G, the interpreter must provide information including name, mailing address, and other contact information where they may be contacted. The interpreter must also provide the business or organization they work for, if any. The interpreter must certify that they are fluent in English, that they read all questions to the authorized individual, and that the authorized individual understood all questions and instructions on the I-956G and verified the accuracy of every answer. As stated above, if any individual other than the authorized individual mentioned earlier prepared and completed the I-956G on behalf of the Regional Center, the preparer must complete Part 7, including the preparer's identification and contact information. This information also includes the preparer's name, mailing address, and any other contact information. The preparer must also provide the business or organization they work for, if any. The preparer must indicate whether they are an attorney or accredited representative, certify that they prepared the form at the request of the authorized individual, and certify that the authorized individual reviewed the form and informed the preparer that all the information provided on the application is complete, true, and correct. As you can see, the preceding parts of the I-956G require individual signatures. Each application must be properly signed and filed. Failure to properly sign the form may result in rejection of the form. Please note that it is not acceptable to use a stamped signature or typewritten name in place of the certifier, authorized individuals, interpreters, or preparer's signature. This includes electronic signatures. USCIS will not accept signatures created by AutoPens or similar devices. Any unsigned applications will be rejected. If we accept the application but then determine the signature is deficient, we will deny the application. However, USCIS will consider a photocopied, faxed, or scanned copy of the original handwritten signature valid for filing purposes. The photocopy, fax, or scan must be of the original document containing the handwritten ink signature. Like the previous I-924A and many other USCIS forms, the Form I-956G features this robust and flexible section for applicants to provide additional information. As noted earlier, many regional centers will need to use this part to provide additional details for various parts of the form. Make sure that the additional information you include in this part is accurate and consistent with the other data on the form, as well as the supporting evidence submitted with the form. If more space is needed, regional centers can make as many copies of Part 8 to provide additional information and file with their application. Regional centers should provide their regional center name and regional center identification at the top of each copy they submit. Attachment 1 is an additional part of a regional center's annual statement that was not previously part of the prior Form I-924A. As stated above, each regional center must provide complete and accurate information on Attachment 1 for each capital investment project being undertaken by new commercial enterprises under the regional center's sponsorship with active EB-5 investors. Once again, for purposes of this form, USCIS considers an active EB-5 investor to be any investor who is seeking classification under INA 203b-5 or who has obtained conditional permanent resident status but not yet filed for removal of conditions. The first few items in Attachment 1 pertain to the Regional Center, the NCE, and the JCE that are sponsoring or undertaking the capital investment project. This information includes the names, ID, and addresses for the aforementioned entities. If a Form I-956F has been filed for the capital investment project, this information should be the same information provided on the I-956F, and the Regional Center should also provide the I-956F receipt number associated with the capital investment project being described. If any information about these entities changed since the filing of the Form I-956F or a Form I-956F amendment, please use Part 8, Additional Information, to describe the changes. Regional centers need to provide complete details on the project, including the aggregate amount of capital invested by EB-5 investors, and a description of how EB-5 capital is being used in the furtherance of the project. Regional centers should also indicate whether 100% of the EB-5 capital invested in the NCE has been committed to the project. If it has been, regional centers should provide the name and exhibit number of the evidence demonstrating so. Finally, regional centers should provide details on the progress made on the capital investment project and the aggregate number of direct jobs created or maintained. Please note that, as indicated on the form instructions, the information requested is for the lifespan of the project. The regional center must disclose, to the best of the regional center's knowledge, all fees, including administrative fees, loan monitoring fees, loan management fees, commissions, and similar transaction-based compensation collected from EB5 investors by the regional center, the NCE, any affiliated JCE, or any affiliated issuer of securities intended to be offered to EB5 investors or any promoters, finders, broker-dealers, or other entities engaged to locate individual EB5 investors. Regional centers must describe the amount of fees, the names of the entities receiving such fees, and the purpose for which such fees were collected. The description of the fees should include the amount collected over the lifespan of the project. If a regional center filed an I-956F for the project, the regional center will have included with that I-956F all investment and offering documents, including, but not limited to, subscription, partnership, and operating agreements, private placement memoranda, term sheets, and marketing materials used in connection with the offering. Those offering documents should disclose certain information, including all material investment risks associated with the NCE and the JCE, and any conflicts of interest that currently exist between these entities or individuals responsible for such entities. Those documents should also disclose any pending material litigation or bankruptcy, or material adverse judgments or bankruptcy orders issued against these entities or individuals during the most recent 10-year period, in the United States or in another country. Attachment 1 requires the regional center to disclose if there have been any material changes during the preceding fiscal year to this documentation. If material changes occurred, the regional center should provide the documentation and indicate the name and exhibit number of the document. Attachment 1 requires its own certification from a qualified certifier. The qualified certifier must certify that after a due diligence investigation, all information provided about the capital investment project in items 13 to 19 is accurate. The RIA added new requirements mandating that the NCE and affiliated JCEs set up a separate account to manage capital investments received from EB5 investors for the project. Attachment 1 requires regional centers to provide the bank name and account number for each separate account set up. In addition, regional centers should indicate whether they have retained a fund administrator, such as a certified public accountant, attorney, or broker-dealer, or investment advisor registered with the Securities and Exchange Commission to manage the funds. If a fund administrator has been retained, regional centers should provide the fund administrator's name and organization, as well as any relevant certification, bar, and/or registration number. Finally, regional centers should indicate if a registered investment advisor or broker-dealer controls the NCE and/or affiliated JCE. If so, the regional center should provide the identifying information for the registered investment advisor or broker-dealer, as well as any certification or registration numbers. You must mail the completed application, supporting documentation, and the correct filing fee to the appropriate address. Applicants should check the USCIS website, uscis.gov, for the most current mailing address. Please note, if you send your Form I-956G to IPO in Washington, D.C., we will reject it. Regional centers must submit the correct filing fee with their application. Failure to submit the filing fee, or submitting an incorrect fee, will result in the rejection of your application. Applicants should check the USCIS website for the current filing fee. The following slides provide information on how to properly submit the correct filing fee, whether you are submitting the payment by check or by money order. Note that you must submit all fees in the exact amounts, and that the filing fee is not refundable, regardless of any action USCIS takes on this form. Please review the Form I-956G instructions for more information. This concludes our presentation. Thank you for your time.